Dobro jutro, poštovane dame i gospodo, ladies and gentlemen. I'm very pleased to be here today to address this distinguished audience at this interesting international conference entitled Competition Law in Transition, Trends and Challenges. And I would like to start by congratulating the organizers for bringing all of us here today. Like many of you, I like competition law. I practiced it for a while. And I think it is important to bring practitioners on competition together in Croatia at the eve of the accession to the European Union. And be aware that the negotiating chapter on competition issues has been one of the last outstanding areas for the successful conclusion of the EU accession negotiations of Croatia. Last Friday, the European Commission closed for its part the negotiations, and it is now up to the 27 member states to make their final assessment of the results of these negotiations, also still on competition, said one of the outstanding chapters, and decide whether the negotiations can be officially concluded and the accession treaty signed. From my part, I firmly believe that Croatia will become the 28th member state of the European Union in the course of 2013. The European Union and my delegation, we have always been supportive of the Croatian authorities, including, in particular in this field, the Croatian Competition Agency, towards more genuine competition standards in Croatia. I would like to touch upon a few issues which I hope will be of interest to the audience here, such as the importance of competition policy, connection between competition and enlargement, dwell on state aid in countries evolving from former centralized economies, and also touch upon the role of the European Commission and some national competition authorities. Why is competition policy of such an importance for the European Union? And I think that you all will agree in this room that a competition policy is fundamental for any functional market economy. The competition policy of the European Union has been for many years, and I'm sure will remain in the future, a cornerstone of the common policies of the European Union and is at the core of European Union integration. Its impact on businesses and consumers has made it a key policy within the internal market, a market of more than 500 million customers, of which Croatia will soon be part. The European Union competition policy is the backbone of the internal trade within the European Union. In other words, the backbone of the single market. By removing barriers allowing for the free movement of goods, services, capital and people, and by strengthening competition, it is estimated that the EU's prosperity in 2006, this is based on some statistics, was boosted by more than €500 for every EU citizen compared to a situation without the single market in 1992. And this amount can be doubled if the remaining single market barriers are eliminated. The opening up of national markets and the resulting increase of competition has driven down prices of, for example, internet access, air traveling, telephone calls, and so on and so forth. Faced with a deep economic crisis from which we are only slowly emerging, it is essential that all actors in the economy limit anti-competitive behaviors which can worsen the economic situation. States should refrain from adopting protectionist measures, from opposing liberalization in the utilities markets, or from pursuing state assistance to inefficient companies. Economic operators should refrain from entering in agreements limiting competition by fixing prices, limiting production or providing for sharing markets and customers between them, or simply trying to squeeze out competitors by abusing their dominant position on the market. Both of these types of behavior or policy hamper competition conditions and have consequences on competitiveness and economic growth. Companies become less efficient and innovative. They offer less varied goods and services to intermediate users or final users at higher price. On the other hand, a positive context of healthy competition triggers virtuous circles of innovation, improvements on cost and efficiency, diversification, and ultimately reflects on better consumer satisfaction. Let's reflect on the enlargement and competition. The challenge of building an effective competition policy in a candidate country is not only about transposing the well-known acquis in the competition field, well ahead of the accession day, but also about showing that the country is able to implement it concretely through a credible enforcement record. Let's step back and reflect on the more general process of the EU enlargement for a second. This negotiating process is very special, as it is built around strong conditionalities, the so-called Copenhagen criteria, and related to rewards from becoming an EU member state for the acceding country. The process is well structured around a framework which in the Western Balkan countries is the stabilization and association process, which translates into comprehensive and country-specific agreements, the so-called stabilization and association agreements, establishing common political, economic and commercial objectives. Trade concessions are offered together with substantial financial assistance. If we look at the EU10 enlargement, the one which was finished in 2004, de facto many building blocks of the competition acquis were already integrated in the enlargement countries, well ahead of the real accession date, through bilateral agreements and the Europe agreements. Effectively, the EU acquis in competition matters was directly applicable, at least on the bilateral trade dimension between the EU and the individual candidate countries. On the enlargement path of Croatia, we have seen a similar trend. The EU competition policy was already directly applicable in Croatia before the signature of the Stabilization and Association Agreement in 2001. The Croatian Competition Agency began to use and refer to relevant EU competition regulations already well before being formally obliged to do so, as a well-established practice. The Stabilization and Association Agreement, in short SAA, built on these blocks by setting out precise rights and obligations in competition and state aid areas. Through the SAA, the EU granted Croatia almost unlimited duty-free access to its market for virtually all products. This is important and has been important for Croatia because Croatia's exports to the EU represent something like 65 to 70% of its exports worldwide. And this is the reason why the EU insists on embedding the competition rules already in the SAA or as early as possible in the process. The rules should help create a level playing field to allow for the full realization of the potential trade dimension of the SAA in the first place, and in the second place, to train the economic sectors of the country to face competition. There are also independent and obvious benefits from doing so, irrespective of the accession conditionalities, in terms of the potential economic growth, by creating a level playing field for the economic operators. From the beginning, the Croatian Competition Agency met an increased workload, which came from a growing awareness by the entrepreneurs of the possibility to use the legislative tools available to defend themselves against anti-competitive pressures. The agency also initiated ex officio at an increasing rate. Both of these aspects show a very early induction of Croatia into the EU path as regards competition rules. The path was marked with difficulties, obviously, because of the initially limited enforcement powers of the agency and in a quite unclear role of the court's system. Both of these issues and others have been tackled by the new competition law, which is in force since October 2010. The European Commission considers the Croatian competition law now to be in line with the acquis. But in line does not mean that one cannot do even better. Meaningful and inclusive consultations of all stakeholders should be a precondition for adopting or amending any law. Full transparency is the key. An early implementation of the EU competition policy in Croatia has presented an excellent training field for a future successful participation in the EU market. Time is needed to develop the capacities to cope with competitive pressures and market forces stemming from the EU market. However, it is up to the Croatian companies to meet these challenges in order to take advantage of the single market. They have to go to the market. The market is not going to come to them. By the time of accession, the Croatian economy has to be accustomed to deal with and act in an environment where economic decisions are driven by the market and by competition. Companies must have learned to accept that they are bound by the competition rules, and the competitiveness of Croatian companies must increase. They still have time for this, but they should start today, not tomorrow. Economic operators need to know well in advance, and not only on the occasion, on the day of accession, that the EU rules will strongly influence their market behavior. In this sense, the track record of the agency has been instrumental in raising awareness of the competition rules and policy among the business community, the legal community, and consumers. Few words about state aid in former centralized economies. Speaking of state aid issues, as in many other previous enlargement countries, the presence and the role of the state in the economy in Croatia is still quite large, quite in line with a gradual evolution from the past economic state-centered systems towards a market economy. It is the heritage of centralized economic decisions and the related lack of entrepreneurship which matters, more than the share of the national economy still under state control. Croatian entrepreneurs should not always turn to the authorities to solve their problems. They should solve their problems themselves. This issue was already prominent in a report adopted by the Croatian Competition Agency back in 2003 with regard to the importance of establishing the legislative framework for the obligations to be assumed by the Republic of Croatia under international agreements. And I quote, "The traditional forms of protection of free enterprise by applying competition rules such as a ban on cartels, abuse of dominant positions, or prohibited concentrations cannot entirely ensure equal opportunities of undertakings for business success simply because they ignore an entity having a major influence on the economy, i.e. the state. The transition from the state-run economy into a market economy thus involves a need to redefine the role of the state in economic life. State interventions in the economy may take various forms: subsidies, guarantees, debt write-offs, preferential sale of state-owned real estate, etc., and significantly influence the competitive position and the final business success of individual undertakings. It is therefore necessary to regulate the system of approval and monitoring of state aid in order to achieve the socio-economic goals of the state, while at the same time abiding by the principle of equal rights of all market players to success." End of quote. Now, what will happen, or what does generally happen after accession? After accession, with regard to the antitrust rules, the European Commission will gain competence for major cases with cross-border effects. But those cases with exclusive national reach will remain under national competence.